there's a lot to unpack there, so let's try to take this sort of step by step, because there's a lot going on here, and there's a lot of forms of AI, and a lot of forms of IP. So let's begin with training data. And we talked a little bit about this beforehand. A lot of different countries have, needless to say, taken different stakes on this. So for example, many of the US clients I work with openly admit, candidly steal it, right? So even OpenAI recently got caught using what was called Z Library, which is essentially an infringing repository of books and articles and things like that they absolutely stole. And their contention in the US context, at least, is that they're allowed to do that because the training of the model basically devolves into nothing but mathematical representations that work, yada, yada, yada. Needless to say, people like Scarlett Johansson strongly disagree. They're suing. But let's start off with everyone's perspective on this. So from the perspective of training data, what are your thoughts on ownership? What are sort of the trends you're seeing in terms of how jurisdictions are approaching it?
Yeah. Actually, this is an important issue in the AI industry because the development of AI relies on a large volume of data. And generally speaking, the data comes from the public domain area. About 5 years ago, I advised a startup company which produced an AI generator program for drawing pictures, like Photoshop, AI generated Photoshop. They use publicly available pictures to train the AI model. Such as the cat of Kindle, Kindle platform, or the 𝐴𝐽, this kind of public available images. They asked the question: is it allowed for me to use the copyrighted works without authorization? Well, different from US law, where there are four-factor adoption. In this PRC, we only have exceptions, which is considered fair use. And the use picture for AI training does not fall within any of the exceptions. However, I don't want to say no to my client, because I understand that they must do that. So I try to develop a methodology to help the client balance risk and benefits. Law is not about right or wrong, it's about the balance of risk. So I find that if you are able to control every training stage internally, and you can control the output of the result, and it only produced to those who have been authorized. For example, if you are going to draw a picture for 𝐴𝐽, you can use the output, the text, for the rest of the company with authorization. But for the rest of the world, you do not produce the work exactly the same or with sufficiently similar to original work. If you can do that, the risk is manageable. Now, after 3 years, although we don't have a copyright case like the States, but we have some similar case, which I believe is consistent with my suggestion.